With profound humility, my Lord, I am I.A. Kamadin for the defendant.
Therefore, both defendants.
Yes, my Lord.
So what that means that is that claimant is not represented. Claimants are not represented.
From what I heard from the claimant, they said he's on his way coming.
And they were communicated, they were informed now.
Yes.
Yes, I'm going to take the judgment now. Maybe he will come and join us. He doesn't have to. He can as well connect to the this thing wherever he is. So this is the court. Asaba by, as usual, referring to the claims of the claimants before this court, and then I summarized and the defense, the lowest. Claim of the claimant, the defense of the defendant, and I summarized the submissions in the final written addresses of the parties. I will summarize the submissions. I want to start from the judgment. Okay, so the court decision, yes. As we're going through the relief sought by the claimants before this court, defendants' response thereto, as well as the submissions and the respective written addresses of the parties, this court holds the view that the issues for determination in this case are as follows. One, whether the defendants have established with credible evidence the offense for which the claimants' employments were determined by them before this court. And so whether the court correctly find that the claimants were given fair hearing by the first defendant before their employments were terminated. And then thirdly, that's the third issue, whether claimants are not entitled to the reliefs being claimed by them before this court. So I took issues 1 and 2 together. And generally, the status position of the law is that in civil cases, the onus of proof on the claimant to establish his case with credible evidence before the court, before he can be entitled to have the court grant judgment in his favor, and the burden of proof lies on the person who desires the court. Desires the court to give any legal to give judgment as to any legal right or liability depending on the existence or non-existence of facts which he asserts. It rests squarely on the party who asserts the affirmative to a particular issue and who will lose if no evidence is given at all in the case. This is called the legal burden of proof. This is, however, without prejudice to the evidential burden of proof, which is vested on the parties by the state of the pleading in a case. What legal burden is starting, the evidence burden shifts from one party to the other, depending on the state of the pleadings. Now refer to the case of Odom and PDP and the case of Egariva against Osagi. The citations are supplied. I've also cited Section 133, Subsection 1 of the Evidence Act 2011 as amended. However, also the settled position of the law that where the employer gives a reason for terminating the employment of an employee, the employer bears the burden to establish the reason so given the satisfaction of the court. Otherwise, the termination will be declared as wrongful. Now, right on the case of Afribank Nigeria PLC against Oshuke. Citations are supplied. From the surface of the letters of termination of the first, third, and fourth defendants, the reason given by the first defendant for terminating the employment of the claimant is that their services were no longer required by the first defendant. However, it is clear from the evidence led before this court that the allegation which led to the termination of the employment of the first, second, and third and fourth defendant is that the first defendant collected the sum of 500 from a commercial bus driver, while SRC Moses Abutu, that is DW1, watched through the side view mirror of the bus, and he immediately got down from the bus and heard the first defendant with the sum of 500 naira collected by him because he was part of the surveillance team from the first defendant's headquarters in Abuja, and that the other patrol members and other claimants ran into the bush to discharge the money in their possession already collected from the passenger. The first defendant flung the handkerchief in his possession, and the sum of 500 was recovered at the scene near the rear tire of the patrol vehicle on the ground. That was the money collected from the driver. It was the money collected from the driver. At the panel, the charge against the aforementioned claimant is that the sum of 500 naira was found at the vicinity of their patrol vehicle, contrary to and punishable under Regulation 23, Sub 2B of the FRSC Regulations on Discipline 2018. A disciplinary committee was set up for them who found them guilty of the offense and recommended that their employment with the first defendant be terminated, consequent upon which their employment was terminated. Claimants appealed the decision of the disciplinary panel of the first defendant. The federal affirmed this decision in respect of the claimants, but converted second defendant's termination to loss of seniority for a period of 1 year for abandoning their duty post. The law is tried that the court can only decide any case before it based on the evidence laid before it. Also, the second portion of the law is that the standard of proof of a crime is that of beyond reasonable doubt. Even when there's allegation of crime in a civil case, standard of proof is beyond reasonable doubt. I've relied on the case of Esagwedu against the state, and then section 135.3 of the Constitution of the Federal, section 135.3 of the Evidence Act 2011 as amended. From the facts of this case, though the first defendant is alleged to have collected bribe or extorted the sum of 500 from the driver of a passenger bus, but no money was recovered from him, but rather the sum of 500 was found on the ground near the rear tire of the patrol vehicle, and all the claimants have denied ownership of the money. So also, W1 testified before the first panel that the video recording of the event at the scene was done and that there were other people at the scene on that day. As well as submitted by the claimants, no sum of 500 naira or handkerchief was tendered as exhibit before this court. Also, no video recording was tendered. Even the conclusion of the panel was the conclusion of the disciplinary panel was based on the assumption that since the money was found at the vicinity of the patrol, at the vicinity of the patrol, it belongs to the claimant, and they should be held liable for gross misconduct under section 23(2)B for the First Federal Regulation, CSBT E. In the circumstance of this case, I find and hold that there's no evidence specifically linking the first claimant or any of the claimants, defendant's allegation of gross misconduct, bribery, or extortion of the sum of 500 naira from a bus driver, while the claimants were on patrol on the day of the incident. A court of law is not permitted to judge a case based on assumption, but rather on credible evidence. I never hold that the defendant has not proved the allegation for which claimant's employment were terminated, thereby rendering the termination as wrongful. Defendants have argued that the claimants do have the evidential burden to prove that the defendants illegally and unlawfully terminated their employment, as the defendants in paragraph 2 of their statement of defense stated clearly that the act of the claimants of being in possession of the undeclared money in excess of the declared 1,000 naira or any other undeclared money found in the patrol vehicle or within the 20 meters radius of the patrol point, the entire team shall be deemed to have committed the act of gross misconduct and shall be liable to termination. That the sum of 500 found within the vicinity of the patrol, which none of the claimants accepted ownership of, is contrary to its extant law, specifically section 32(b). Excuse me. Of the regulation 2018, which amounts to gross misconduct punishable by termination of appointment. It also submitted that claimants' employment were terminated by first defendant because of the adherence of the rules and regulations, which clearly stated the punishment for the offense. In respect of above submissions, there's no doubt that the first defendant reserved the right to punish claimants for any misconduct or gross misconduct committed by them if the commission of the misconduct is established. However, as I stated earlier, defendants first and foremost bear the onus to establish that the claimant actually committed the gross misconduct when the defendant can mete out disciplinary action against them and terminate the employment if it so wishes. The evidence led by the claimant has not established any gross misconduct allegedly committed by them or even the offenses alleged. Also, that the provision of section 23(2) say that when money is of the first defendant, it will be taken that all members of the patrol team are in possession of the money does not accord with fairness and equity, only submitted by the claimants. In respect of the submissions of the defendants that claimants' failure to place their condition of service before this court has robbed the court of the jurisdiction to hear and determine this case, I wish to state categorically that the law is settled that jurisdiction usually vested on a court by the laws which establish the court as well as the Constitution. In order to determine if a court has jurisdiction, what the court should look at is the claims before the court. The claim in this case borders on determination of employment, and this court has been given exclusive jurisdiction by section 254C, 1 and 2 of the Constitution of the Federal Republic of Nigeria, Act 2010, to handle such matters. Note that this court has rightly assumed jurisdiction over this case. In any case, claimants' conditions of service are not already in issue before this court. Claimants have alleged that they were not given fair hearing before the summary panel for the first defendant. The principle of fair hearing has twin pillars. As encapsulated by the Latin maxims, audi altera partem, which means head the other side, and nemo judicat in causa sua, which means that a man cannot be a judge in his own case. The principle of fair hearing is enshrined in Section 36(1) of the Constitution of the Federal Republic of Nigeria as amended. Fair hearing has been held to mean a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. Some of the essential requirements of fair hearing is that justice must not only be done, but it must be seen to have been done. The person against whom an allegation of wrongdoing is made must be personally confronted with the allegation and given an opportunity to defend himself against him. The court must be impartial and fair. Adequate time should be given to the person to prepare his defense. It has been heard that a hearing cannot be said to be a fair hearing if any of the parties is refused the hearing or denied the opportunity to be heard, present his case, or call evidence. And decision reached in breach of fair hearing will be declared as null and void. And it's not a void. See the case of WAEC and Akekumi. Citation is supplied. Audu and the Republic of Nigeria, military governor of Imo State against Nwawa, and the case of Abana against Obi, but their citations are supplied. Where the law stated the procedure for terminating an employment, the procedure must be followed, otherwise the termination will be declared invalid. This portion of the law applies to employment with statutory flavor. See the case of PHMB against Ijitaga, and then Al Hassan against Abu Zaria. The petitions are supplied. The petitions are supplied. And then the procedure for disciplining the claimants under the regulation of the first defendant should start with a sense of query to them, which they will be requested to respond to. First letter was issued with query exhibit I, which states as follows: quote, because that you are scheduled on morning patrol on 16 September 2018 along Ido Erua arresting Masha, but when HQ surveillance visited your patrol point, 500 naira was found on the ground close to your patrol point, which was alleged that you dropped the money. 2, your action is punishable under Part 3, Section 22I of the FRSC Regulation on Maintenance of Discipline 2013, end of quote. In Exhibit P, second and fourth claimants were queried as follows: record that you were scheduled on morning patrol on 16 September along Ido Erua arresting Masha, but when headquarters surveillance visited, you ran away from your patrol point. 2, your action is punishable under Part 3, Section 22G of the FRSC Regulation and Maintenance of Discipline 2013, end of quote. There's no evidence before this court that any query was given to the third defendant, as no such query is tendered before this court. However, the charge prevailed against all the claimants before the disciplinary panel of the first defendant is that on the 16th of September 2018, is that while they were on patrol along the Ido-Erua Road, an undeclared sum of 500 was recovered from their patrol vicinity by surveillance team from the Aru SHQ, an offense authorized and punishable under Section 23, under Regulation 23 COP of the FRSC Regulation on Discipline 2018. Claimants urge this court to note the inconsistencies in the misconduct alleged against the claimants and second defendant, which are contained in the queries issued to the claimant and the second defendant as against the charges brought against them at the disciplinary panel as follows. Contrary to the submissions of the claimants, a query was issued to the fourth claimant. However, I agree that there's no link between the queries issued to the first to the claimants and the second defendant and the charge brought against them at the panel under section 23(2)(b) of the FRSC regulation on discipline 2018, for which their employment was terminated. In my view, this goes to the issue of fair hearing, and I so hold. Also, a perusal of the report of the disciplinary panel or the first defendant, Exhibit F, shows that there was no time that chairman of the panel asked the claimant if they had any witness they intended to call. So I hold that, I wrote this with friends. This answer, this amongst other reasons above, they all have right to be represented by a legal practitioner of their choice. However, the manner of conduct of the proceedings of the defendants panel did not accord with the dictates of fair hearing, contrary to submissions of the defendants. First defendants, the disciplinary panel is mandated by the law to conduct its proceedings according to the dictates of fair hearing. And I wish to state that fair hearing does not end with the composition of the disciplinary panel or whether the claimants were asked if they had any questions for the witnesses who testified before the disciplinary panel. But that fair hearing that the hearing must adhere totally to the dictates of fair hearing, some of which are itemized above, and I so hold. There have been allegations and counter-allegations of inconsistency in the evidence led by the other side. The courts have heard that it is not every inconsistency that will be fatal to the case of a party, but that which goes to the core or root of a party's case. It has been submitted on behalf of the first defendant that the court should disbelieve and disregard the entire evidence led by the claimants, because while a witness gave evidence that nobody ran away from the scene, another stated that he ran away from the scene. In my view, this alleged inconsistency does not go to the root of the evidence led by the claimant, and is therefore not fatal to the claimant's case. I so hold. On their own, claimants have pointed to the contradictions in the evidence led by the defendants to W1 and W2 in the statement of oath at their paragraph 3, that the claimants and the second defendant were investigated for alleged misconduct of being possession of an undeclared sum of 500 naira. But while the W1 statement in paragraph 20 is that he struggled with and wrestled with first defendant who flung 500 naira from the handkerchief in his hand. Second defendant gave evidence before the panel as stated in Exhibit A at page 3 that he, W1, was struggling with the arresting marshal, but he, W1, only found an handkerchief on his hand. That later on, he did not know how come he saw 500 by himself, and that from there, they all went back to the office with the team members. It's submitted by the claimants that while the W1 claimed that he saw 500 naira at the rear tire, second man did not see any money. It's further submitted that the W1 testified at the same page of Exhibit E that W1 had a twice and other operatives, and that one of the operatives started recording them, but the operated recordings are not before this court. And none of the either W1's once, twice, or other operatives were called to corroborate the testimony of the W1, thus raising the inference that the only reason W1 saw 500. I agree with the claimant that these contradictions are fatal to the case of the defendant. For the reasons earlier stated, the proceeding before the plenary panel or the first defendant and the decision taking a person thereof I hereby declare null and void. Issue 3, whether claimants are not entitled to the reliefs being claimed by them. The reliefs sought by the claimants, they are reproduced. I reproduce the claim, the reliefs as 1, a declaration of the purported termination for the first to fourth defendants, fourth claimants rather, under regulation 23(2)(b) for the defendants regulation on discipline 2018 by the first defendant that letters of termination of appointment dated 30th day of April 2020 after be investigated and tried by the first defendant administrative panel on 16th day of September 2018, along with the second defendant, a panel which already found them guilty. Find them guilty of, find them that this is the first to four defendants liable to have committed gross misconduct and other offense, and therefore liable to have their appointments terminated. As reportedly found, second defendant liable to have committed gross misconduct and liable to have his appointment terminated as well. But if you terminate the appointment of the second defendant without justification is unconstitutional and therefore null and void. As same constitutes a flagrant disregard to the principle of natural justice. I just reproduced other claims. The second one is a declaration, the third one is another, the fourth one another, and the fifth claim is cost of the action. They are reproduced on the judgment. And now, I say, in my view, the first relief has been taken care of by the judgment. In respect of the second relief, it's not in doubt that claimant's employment with the first defendant is a questionable one. As regarding relief 3, this court has earlier held that defendant have not proved the allegation that led to termination of the of claimant's employment, and that the first defendant panel did not adhere to the details of fair hearing while trying the defendant. Also, it is not an issue that the claimant's employment is with statutory flavor, as it is regulated by the First Defendant Act and Regulation 2018, the 2018 regulation of the first defendant made person thereto. As a result, the court hereby holds that the first defendant should reinstate the claimants to their employment with the first defendant and pay them their arrears of salary and allowances from the month of May 2020. I hold that relief 4 in this case has been taken care of by the judgment. And since cost follows the event, cost of 500 naira is awarded in favor of the claimants jointly. And judgment is sent out accordingly.
Judgment. I formally announce my appearance. Olu Vincent Ogunbowale is my name. My humble appearance is for the claimant. We are much obliged. We have to thank your Lordship for the well-considered judgment. You urge your Lordship. I mean, we will pray that your Lordship have the benefit of the higher bench while still in service. We are much obliged.
Thank you very much.
Lord, we are most sincerely grateful for well-delivered judgments. May the Almighty Allah elevate you more and more. Thank you, my Lord.
Thank you very much. Yes, hello, Sunday.
Yes, my lord.
Call that case.
The adoption, my lord.
Head team. Yes, call the
Case
adoption.
between Adegboye
Because I
Akeem
don't.
versus United Bank for Africa, UBA.
Yeah, so it's rather that part of happening.
Yeah, my lord. Parties are asking.
What? Okay. Yes, it's Clever's council around.
Not my lord.
It's around.
It's not around.
Okay, yes, appearance, please. Appearance. Sunday. The countries are not there.
They are not here, my lord.
Okay, they're not connected.
We are surprised.
Hello, my lord. I'm here, my lord.
Okay.
Yes, my lord.
I don't see appearance, man.
Aro Morano is my name.
Ah,
Aro Morano is my name.
okay, Aro.
Morano.
Okay.
I appear with respect for the defendants.
Clever's council is not there. Okay,
My lord, I could see the, with respect, sir, I could see the claimant counsel on screen. I don't know why he has, I can see him on screen.
Maybe he has problem with the. Maybe he has problem with his.
Hello. I can hear my lord clearly.
Okay, yes, I don't say appearance, please.
A Adejola for the claimant, my lord.
Okay.
My lord.
Yes.
My lord, we have two pending claimant's final written address, my lord.
Two pending. Why two?
I seek to withdraw the one filed on the 2nd of May 2024, my lord. It was filed before the claimant, the defendant written address was deemed properly filed.
Okay, but you're supposed to file. Have you filed the motion? The motion that.
My lord, I filed another one after the claimant, the defendant have regularized their written address. So I seek to withdraw the earlier one I filed so that the one I filed on the 31st May is properly before the court. There is no need for extension of time.
Okay, you have two defendants.
Two claimants written address.
Claimants written addresses.
Yes, my lord. So I seek to withdraw the one filed on the 2nd of May.
The first one is filed when?
It was filed on the 2nd of May, 2024.
Okay.
And the second one was filed on the 31st of May, 2024. My lord, I seek to withdraw the one filed on the 2nd of May, 2024.
Okay, you said to withdraw the first one that was filed on the 2nd day of May 2024. I said you said to withdraw the first one.
May. Yes, my lord. Withdraw the first one, my lord.
Okay. Let me hear from Mr. Amrano. Do you have any objection to that?
I don't have no objection.
The one filed on 2nd of May, is also dated 2nd of May?
Yes, my lord. It's also dated 2nd of May, my lord.
Sorry.
So I've said that the claimants, okay, it's claimants.
Yes, my lord.
Claimants final written address dated 2nd day of May 2024 and filed on the same date is accordingly struck out.
As call, please. My lord, the claimant's written address dated and filed on the 31st of May 2024 is now proper before the court, my lord, and I seek to adopt same, subject to the convenience of my lord.
What about the defendant? Supposed to start with the
Yes, my
defendant
lord.
now.
Yes, my lord.
It has been served.
It has been served.
Oh, what I'm saying is that the adoption should start with the defendant now, ordinarily.
Well, very well, my lord.
Yes, my lord.
So defendant.
Yes, my lord. Yes, my noble lord. The defendant final written address is dated 15th day of December 2023. But filed on the 18th day of December 2023.
Yes.
My lord, the said written address was deemed as properly filed and served on the 23rd day of May 2024.
Or 20, did you say 25th?
23, my lord. 23rd. 23rd, my lord.
May 2024.
2024, my lord. Yes, my lord.
Okay, no wonder. He was saying that 5 wouldn't. Okay, yes. So you seek to adopt him?
I seek to adopt him.
Yes.
As the defendant's final written address. In this case.
As the argument.
As an argument. In this case.
And
how my noble lord?
This as your argument.
In support of the defendant case.
Yes, okay. As adopt him as our argument. Support
of the defendant's case.
Defendant's case. Yes.
And I hold my noble lord.
Yes.
To dismiss.
Dismiss.
The claimant's case.
The claimant's case.
Yes, my lord. To dismiss the claimant's case.
Okay.
For want of evidence or proof.
Okay.
My noble lord.
Yes.
I want to know if I could see adopt my reply point of law now, or I should wait till he adopts his final address.
You can adopt it.
Okay, my lord. My lord, I just have a normal application that the defendant reply point of law was filed on the 16th day of May 2024.
Yes.
My lord, I most strongly apply
Yes,
that the court should deem the said bond of law
yes,
as properly filed and served.
yes. Was it filed out of time?
Not really, my lord. It was filed before. It was filed after the claimant first finality address, which he withdrew today.
Okay.
So, in order not to unjust my lord's fight, I think there's no point since there's nothing different in the first argument that is not in fight now. So
Okay, just adopt it now.
yes, I'm on to adopt, my lord. I adopt our reply on court of law filed on the 16th of May, 2024. Deemed as properly filed and served today, 27th of June, 2024.
So them
It was deemed as properly filed and served today.
addresses
Yes,
of the claimant. We the court to do same as properly
filed and served.
Properly filed and served. Okay, his name as properly
filed and served. I'm brief, my lord.
Yes, Mr.
Yes, my lord.
Adejola, my lord.
Mr. Adejola, you have any problem with that? Do you have
No, my lord.
Okay.
No objection, my lord.
Oh, okay. So say order as spread.
I'm brief, my lord.
Order as spread. Then, Mr. Amraino, you can now adopt the same the points of law.
I'm brief, my lord. My lord, I adopt the defendant reply to point of law filed on the 16th of May, 2024.
Yes.
Or deemed as properly filed and served today, 27th day of June, 2024.
Yes.
As the defendant's argument on point of law
Yes.
to the claimant's final written address.
Yes.
And humbly, I want to crave the court indulgence for 2 minutes and duration of our address.
Yes.
Honorable Lord, the case presented by the claimant before the court has to do with wrongful suspension.
Yes.
Based on the defendant's handbook, the purported defendant's handbook.
Defendant what?
The defendant's purported handbook.
Handbook, okay.
Yes, my lord.
Yes, please.
Oh, Lord, the claimant did not put in evidence
Excuse me, please. So claimant did not
put in evidence the said defendant handbook, which he alleged the defendant contravened in suspending him.
Yes.
Hence, he left the court in darkness
Yes.
as to which particular
Yes.
section of the handbook the defendant contravened.
He said it caused what?
He left the court in darkness as
Okay.
to which of the said handbook, the section, the particular section, or the law, or even the handbook itself, which he alleged the defendant contravened.
Yes.
And contrary to the case presented by the claimant.
Yeah, you should be running off your underbration now.
Yes, my lord, I will do, my lord. Contrary to the case presented by the claimant in his trial, the claimant during at the final written address, in the final written address, changed their case from unlawful suspension
Yes.
to termination of appointment.
They did what?
They changed their case, contrary to what they placed before your lordship, and which they laid evidence upon. They changed from suspension, from wrongful suspension to termination of appointments.
Yes.
Which is never their case before your lordship.
Yes.
My lord?
Yes.
It's our humble submission that the Honorable Court lacks jurisdiction to pronounce on the relief which was not placed before the court.
I believe everything is in your, it's not in your reply.
Yes, my lord. Yes, my lord. Yes,
That's the essence of the.
Yes, my lord. We are just trying to. Yes, my lord.
No, it's there. If it's there, then it's there. You don't need to repeat.
As my lord,
Because
just do.
Read it.
Okay, so that's just the key point, that the issue of wrongful termination of employment is not before your lordship. What they brought before your lordship has to do with suspension, wrongful suspension of the claimant, and they allege that the contravened our handbook, and they said that book is not placed before your lordship. So, my lord, another issue we have probably formulated 3. So we urge the court
Yes.
to dismiss the claimant's case with cause as same is frivolous.
As what?
As same is frivolous.
Okay.
We are most grateful, my noble lord.
Okay. Thank you. The claimant's counsel.
Thank you, my lord. My lord, on behalf of the claimant, we filed a claimant's final written address.
Claimant's counsel
my
is
lord, the said final. Yes, my lord. A.A. Adejola, my lord.
I just wanted to clarify there. Yes. Yes, please go.
My
go
lord,
ahead.
On behalf of the claimant, my lord, we have filed the claimant's written address dated and filed on the 31st day of May 2024.
Dated and filed
on the 31st day of May 2024, my lord.
Okay.
My lord, we adopt the argument contained in the said written address as our argument in support of the claimant's case. And urge the court to grant all the prayers sought for by the claimant in this suit. My lord? My lord?
Yes.
By way of adoration, my lord.
Yes.
My lord, the case of the claimant,
yes,
was that his appointment was never formally terminated nor suspended. It was orally suspended by the defendant. Orally suspended by the defendant. There was no letter of termination nor letter of suspension issued and served on the claimant. Further, my lord,
yes,
the defendant counsel argued that failure of the claimant to put in the handbook of the defendant is fatal to the case of the claimant. I urge the court to discountenance the said argument on the fact that
yes,
what binds the claimant and the defendant together is the contract of employment. And it is in the contract of employment that spelled out the way and manner the defendant's employment will either be terminated or suspended or be dismissed. My lord, the said letter of appointment, which is the contract of employment, between the claimant and the defendant, was put in the evidence.
yes.
And the said letter was marked as Exhibit A by the Honorable Court.
And this submission now it's written down. All this
Yes, my lord.
I'm looking at double because I saw when I was reading this thing, I saw it there.
Yes, my lord. Yes, my lord.
So if it's written down, you don't really need to repeat.
As God pleases. My lord, I heard the court to discountenance all the arguments canvassed by the defendant counsel, uphold the claimant case, and grant all the claimant's prayers before the court. We are most grateful for my lord's indulgence.
Okay. Okay, so I'm trying to see a handbook.
Yes, my lord. First name, my lord. I'm sorry. My lord. I'm sorry.
Now, what's the problem again? Now, you have taken your turn now.
Yes, I've taken my lord. Because when I was adopting, I did make mention of handbook. What I meant by that is what the document referred to in the claimant's relay, which is titled Defender Group HR Disciplinary Process and Sanction Policy. It's stated in relief one of the claimant's.
I'm not going to write this down again. Since you have already made your submission.
I'm sorry.
As God pleases.
Oh, the question is ending with their own now.
I'm sorry.
As God pleases. As God pleases.
I'm sorry, madam. It's the defendant's disciplinary process and sanction policy. That's what I mean by handbook. I'm sorry, madam.
Okay, so I've said that.
I'm giving my law for the indulgence. I'm giving my law that. So that's just the clarification I want to make, sir. I'm most grateful for the indulgence, sir.
You're welcome.
Thank you, my lord.
So I've said that case is adjourned for judgment on a date to be communicated to the council.
As God pleases.
Gentlemen,
yes, my lord.
The date I'm looking at is upper week.
As God pleases.
This week is gone now. This is the end of June. I'm looking at second week in July. To just prepare, we'll communicate you in due course.
As God pleases.
We're working on the judgments, and so we'll communicate to you.
As my lord pleases.
We are most grateful, my lord.
We thank my lord for the indulgence and the patience, sir. We are grateful, sir.
Okay, welcome. Okay, bye.
Thank you, my lord.
Okay, bye. So that's the end of the sitting. Thank you. So, come and take your listing. It's not showing. It's not bringing it of where somebody can live. Where is the live?
Thank you, my lord.
Okay. Sunday.
Okay. Yes, my lord. Welcome, my lord.
Okay, Rebecca,
yes,
she made here. Ẹ máa bí concept fún bọ́jà ó rẹ̀ ní stress yẹn pọ̀.
Sorry, my lord.
Tí mò ń jọ́gù. Ok, ẹ ṣe wẹ̀yí ti Ìbàdàn area. Ẹ kú gbádùn o. Sunday tiẹ̀ ti sá lọ́ntì. Sunday Sunday. Mo ló ti sá lọ́ntì.
Àbí o.
Gbúre ló lọ. Gbúre àti
láfù.
So okay. Take care o.
Yes, my lord.
Take care.
Yes, ma'am.
Òde ìwé kàtọ́ mi bá ti dàgbà, wọ́n máa bọ̀ lásàbà. Ọkọ̀ ìpínlẹ̀ àwọn máa dàgbà, wọ́n máa bọ̀ lásàbà tó bàjẹ́, wọ́n á ti gbé kúrò lásàbà ní láti ẹ̀sìn kúrò. Bàbá mi máa dàgbà, àbádìpọ̀ bọ̀ lásàbà.